Single tracking suddenly. It's all getting better. Oh, yeah. That's right. Well, Fred was interesting.
Yeah.
Well, I think he's one foot in, 1 foot out.
Yeah. Yeah.
Yeah.
And he has some biases about what it needs to be quite well, it's I don't get to see the whole picture, and there's still this underlying unresolved disease. It's about here when you're doing my relationship with Phil. So he was that whole square box. But the most practical part of it is true practical substance for the thing which my house. What he said, I think, is right. This is that Bill right about he is and Fred said is that words are private. It's great. Is that the other party says something. It isn't right. It isn't whatever. Bill would not. Yeah.
So, PJ has makes a statements that were untrue and not right. So
Yes.
there's a lot there.
I know.
Yeah,
To rebuild it from back and they're just not
what Fred said is that Bill would just have so when he goes into the meeting, this that's why Fred said I should other thing that was on he's was on his was that for LA,
We have like a lot, like per each section, so many.
it's highly risky to get drugs under at this late stage because they will see that they have the opportunity to rapid growing that where he lives across the street down to about right person in the area. He's talking to her she's not
Good to see you.
Yeah, no, you are in the batter's box. If he starts to stutter or smell coffee on his leg.
Good morning, everyone. Welcome to the Bipartisan Policy Center, and thank you for coming out on this rainy morning. I'm Bill Hoagland, Senior Vice President here with the Center, and I have the pleasure of working with our health team on several health policy issues that confront our country today. And of course, one of those terrible problems is and has been the scourge of this opioid epidemic. The latest statistics I have found from the National Prescription Audit indicates that at least over the last 2 years, we've had a reduction in the prescribing of opioids as measured by morphine milligram equivalents. Nonetheless, we've had more than 70,000 people die from drug overdoses in 2017, and nearly 50,000 of those deaths involved in opioid. And let's bring these numbers home real quickly. It is estimated that over the next 2 hours as we sit here, 12 Americans will die from an opioid overdose, and at least 4 innocent babies will be born addicted to opioids. This is incalculable loss, not to mention the suffering caused to families and communities devastated by this disease. It also has a public cost, and with both treatment, prevention, and recovery. BPC recently released a one-of-a-kind comprehensive report that tracked just appropriated funds, federal appropriated funds for 57 opioid programs, federal programs. You could have picked up a copy of it on your way in, but if not, there will be copies outside as you leave. For the last 2 years, 2017 and 2018, the federal government has expended over $11 billion for these programs. And this figure does not include $2.5 billion that we've spent on Medicaid opioid treatment drugs over those 2 years. The report concludes that federal funding to the states needs to be more flexible, sustainable, coordinated, and transparent. So to today's discussion. This morning we are particularly honored to have the Attorney General from the great state of Oklahoma, Mike Hunter, with us. The AG has made the safety and security of all Oklahomans a key portion of his term in office. I was interested in seeing that Attorney General received his law degree from the University of Oklahoma College of Law and his undergraduate degree from Oklahoma State, making him the first state Attorney General to receive an undergraduate degree from Oklahoma State. Oklahoma has not been spared from this epidemic, complicated by its rural environment, highlighted, as some of you may have seen in yesterday's front page of the Washington Post, story about the struggles Fairfax Community Hospital in Osage County, Oklahoma is facing from closures due to lack of resources, workforce, and supplies, while still having to deal with opioid overdoses in its emergency room. The Attorney General will discuss with us his state, his $270 million settlement with Purdue Pharma. Following his comments, our President Jason Grumet, will have a fireside chat. Imagine a fireside, please. We don't have one. And Jason will leave some time for audience questions. And then an expert panel will be moderated by Regina LaBelle. Regina was the former Chief of Staff of the White House Office of National Drug Control Policy and has been a very valued consultant on our opioid work here at BPC. So without further ado, the 18th Attorney General of the state of Oklahoma, Mike Hunter.
Well, good morning, everyone. You know, Bill failed to mention, and I appreciate that, but I'm going to make a confession here. My wife, Cheryl, who's my lawyer, thought it was a good idea to bring my lawyer this morning. Anyway, we lived here in the D.C. area for a number of years. I work for financial services industries principally. First for the American Council of Life Insurers, and then later I served a 4-year sentence with the American Bankers Association. And in the recent election, and I stood for election in 2018, I was reminded of those tours of duty here. Because for, as you probably know, outside of Washington, D.C., this place is known as the Swamp. And so there was all sorts of TV advertising and pamphlets that accused me of being part of the swamp and an influence peddler. To the best of my ability, I tried to provide mitigating circumstances. Banks and insurance companies are important. So that leads me to maybe a little bit more of a confession. I am a conservative Republican, Reagan Republican, if you will. My legal career has found me representing energy companies and, as I mentioned, financial services entities. It has been my experience, it's been my training, been my education, that capitalism works, markets work, supply and demand works, but sometimes there are rough edges in that continuum. Peggy Noonan said about Ronald Reagan that he believed that people do as much good as they can and as much bad as they think they have to. I think in many ways that describes perhaps some of the mistakes or misdeeds or misadventures that we see out there in corporate America. There is great pressure on companies from top to bottom to meet earnings expectations. There is great pressure to ensure that you're capturing as much of your customer base as you can, and that pressure flows from top to bottom. And sometimes that pressure creates mistakes. And let me just take you to a point in time in the mid-90s when there was a decision made among the medical community that there needed to be a fifth vital sign, okay? And that fifth vital sign was pain. And there began to be this obligation that was imposed on healthcare practitioners that unless you are dealing with a patient's pain in a decisive way, you are not doing your job. You're not treating your patient in a responsible way. So to fill that space, a magic pill was sort of the challenge for pharmaceuticals. Can we come up with something that can be given to patients that will eliminate that pain, that will, in a, as I said, decisive way, help that patient deal with his or her pain? And in this stampede, you know, in this mad dash to come up with a magic pill, a company, Purdue Pharma, which it has been chronicled in I think, a way that is authoritative. They originated the opioid analgesic. And the assurance that was given prescribers over time was that this time-release formulation present in this new opioid analgesic would avoid addiction. Now, there's all sorts of lessons in the history of this country with regard to the use of opioids for chronic pain. It is and has been very imperfect. After the Civil War, after World War I, there were, believe it or not, two experiences this country had with opioid epidemics. It used to be called the soldier's disease. So in both those instances, there was a response by government, and opioids were outlawed as something that could be prescribed for pain. So fast forward to the mid-90s, these new products are being introduced with no research, no studies, no trials. There was simply a study performed by a doctor and his associate of patients in a hospital who, in a very carefully supervised, contained setting, were provided opioids to deal with their pain. And guess what? In that carefully supervised clinical setting, they found very little incidence of addiction. And so that was used in a general and misleading and, as far as we're concerned, fraudulent way to reassure prescribers that opioids were not addictive. So, Oklahoma, 2017, I've been appointed Attorney General, and as our team and I sat down and began to chart a course for what our priorities needed to be in the office, there was this continuing attention of the negative vector in our state, that negative vector being the opioid epidemic. If Oklahoma's not ground zero, they're certainly close. And let me just share some data points with you. Between 2004 and 2018, there have been more than 10,000 overdose deaths in the state driven by the opioid epidemic. Between 2014 and 2018, there were more than 2,500 overdose deaths attributed to pharmaceuticals. And this is likely an undercount because until last year, the medical examiner didn't have to do toxicology reports on all overdose deaths. In the last 15 years, drug overdose deaths in the state have increased by 91%. In 2016, in the 14 counties surrounding Tulsa, our second largest city, there were enough prescription drugs available to provide each person, each man, woman, and child with 90 pills. Between 2015 and 2018, there were almost 18 million opioid prescriptions filled in the state. And I'm not sure there's any more jarring data point than this one. Between 2017, July, and October 2017, the Department of Human Services in the state received 841 referrals regarding substance-exposed newborns. I'm not sure I've seen any more disconcerting, maybe nightmarish is a better adjective, video than an infant, a newborn infant, within hours of he or she drawing their first breath, going into substance withdrawal. In 2016, 66% of drug deaths in the state were due to pharmaceutical drugs. And as Bill indicated, the epidemic is abating in a measurable way around the country and in our state. Deaths have gone down, but that has occurred because of policy changes we've made. We now have prescription monitoring programs, and we also have prescription limits on opioids being dispensed by healthcare providers, prescribers. But we continue to be concerned by statistics like this. In 2018, there were over 3,000 non-fatal overdoses in our state reported by hospitals just last year. And nearly 80% of those were directly attributable to pharmaceuticals. So, this was a tough call for me. It was a tough call for our team. This being going into court and suing Fortune 500 companies in many respects, big companies, well-financed, well-resourced companies, companies that do good, and in this case, have done, in our judgment, a lot of bad. And as much as we don't like to admit it, those of us who are conservatives and those of us who believe in markets and competition, sometimes businesses do bad things. And this is one of those instances. So, decision was made. After careful consultation, I chose a law firm in the state. It just so happened these two attorneys, the senior partners, had been successful getting the largest verdict in the history of the state. I'd worked with the senior partner there, Judge Mike Burridge, former federal judge. We worked together to negotiate a water settlement in Oklahoma with the Choctaw and Chickasaw tribes a few years ago. We also worked together on a university hospital issue that was incredibly complicated. I was convinced Mike was among the best attorneys I'd ever dealt with. And one day we're in the office, coincidentally, and we're talking about this issue that we're looking at in the office, and Judge Burridge said, well, you know, I lost my niece to a prescription opioid overdose, and Reggie Whitten, his law partner, lost his son to an overdose. Son, great football player, became addicted to opioids, being treated for his injuries with opioids, and ultimately lost his life to the addiction. So the more we talked about it, the more I became convinced that we not only had two of the best lawyers in the state, but we had two lawyers who were going to pour their heart and soul into this case. And as a result, I made a decision to retain Reggie Whitten and Mike Burridge as the lead. They put together a legal team. We sued these companies in state court. There were efforts to remove the case to federal court, which we fought and were successful in keeping the case in Oklahoma. Where we are is we have looked at literally millions of documents. We've taken hundreds of depositions, and we are even more convinced than we were when we began this enterprise that these companies are the proximate cause for the epidemic in our state and in our country. So as we have moved closer to trial, May 28th, it's going to be televised, national TV, I suppose. We have been in supervised mediation with former federal judge Lane Phillips, and so we've had multiple mediation events over the last several months. And as we spent a lot of time with Purdue Pharma, it became clear that we had a tough decision to make. And Purdue Pharma being a privately held company, bankruptcy was a much simpler, much more elementary proposition for them than for a publicly traded company. And their admonition to us was, we are not going to go to trial in Oklahoma. And frankly, if I was their lawyer, I would be giving them the same advice. Given the exposure you've got in over 1,000 lawsuits around the country, you need to look at limiting your liability. So as we spent time with Purdue in what I would, analogize to the situation we're sometimes in, hand-to-hand combat, there began to be sort of an opportunity. We did not want to force Purdue Pharma into bankruptcy, okay, because that would have stayed our lawsuit, and the consequence would have been zero for the state, or effectively zero. We wouldn't have had a final judgment. We wouldn't have had anything to collect. So as we talked, we came up with an approach. We know that you don't want to settle with Oklahoma and have the Oklahoma judgment or settlement being a precedent for the rest of the states or for the multi-district litigation in Ohio. What if we were to craft a settlement that would allow you to invest in Oklahoma in a national asset? And where we ended up is something that we really feel good about. It's something that's going to be not only good for Oklahoma, but good for the country. Oklahoma State University's Health Science Center in Tulsa in the last couple of years has developed a really amazing, a really remarkable footprint. The Wellness and Recovery Program at OSU, they've already collected millions of dollars in grants. They are, in many ways, a cutting-edge enterprise with regard to dealing with not only the opioid epidemic, but addiction. So after a lot of give and take, a lot of back and forth, what we came up with is, over time, Purdue Pharma, we have settled this lawsuit with them. The settlement amount was $270 million. About 22% of that went to legal fees. But over time, there will be a $200 million endowment that's made to the Oklahoma State University program. And again, our view is this is integral and an indispensable part of how we deal with the epidemic. It's not only the deployment of money that hopefully goes to wellness and recovery, treatment programs, diversionary programs, but it's going to ensure that the best techniques, the best addiction science is going to be put to getting people well. Because the one thing that you learn when you spend time looking at the epidemic is that the people, in many instances, in fact, I would say the overwhelming majority of people don't understand that they have a vulnerability to addiction. Most research, or most of the research I've seen, and nothing really is authoritative on this, but the belief is that between 1 out of 4 or 1 out of 5 people have a vulnerability. And so you don't know when you're going to the doctor's office and you're being prescribed something that's potentially addictive, that you've got that vulnerability. You know, in Sam Quinones' great book, Dreamland, he describes it as the turning of a key in a lock in your brain. And at this point, we don't know, we don't have the science for how to turn that lock the other way. So, again, the approach here is maybe novel, it's certainly aspirational, but it's not only getting a handle on the epidemic with the best science, but at some point, there needs to be a cure for addiction. And at a minimum, there needs to be some screening process that occurs for patients so that you know going in as a prescriber that this person is vulnerable and that there's full disclosure made to this person. So where are we? We're going to trial on May 28th. We have narrowed our theories of recovery, our claims, to a public nuisance claim. And one of the reasons that we chose to stay in Oklahoma as opposed to going to the multi-district litigation in Ohio was because of the very favorable law we have in Oklahoma with regard to abating a public nuisance. It is a very powerful, expansive power. It gives me the ability as Attorney General to go to court, to identify what the nuisance is, and work with the judge to determine a series of approaches that abates the nuisance. So that's our sole theory of recovery as we move to trial on May 28th. We are very confident in our case. One of the other things that we did, again, to narrow the focus to the public nuisance theory of recovery is we waived jury trial in effect. So the trial is going to be conducted by a judge. It's going to be a bench trial. And so I will conclude by, again, saying that whether we like it or not, there are instances where businesses do bad things. And when that happens, attorneys general, the chief law officer of the state, chief law officers of their state, have a responsibility. They have an oath of office to protect the people of their state. So there's been some suggestion that this is going to expand wildly out of proportion the extent to which public nuisance laws are going to be used around the country. I don't think that's going to happen. In fact, we have intervened in cases around the country where we think public nuisance laws have been abused and expanded in a way that was never contemplated. But this is a situation where public nuisance, that theory, common law and statutory, is designed to protect the people in a community and in a state. And when thousands of people die from drug overdoses attributable to prescription drugs, when you have hundreds of thousands of people who are addicted, public nuisance law is the best and most efficient way for you to protect the people of your state. And that's why we chose that approach to this case. And again, we're very confident in what we believe is going to be a successful trial. It will last through the summer, and we we hope you all will be glued to your television this spring and summer. So with that, I very much appreciate being invited by the Bipartisan Policy Council. You know, there used to be a Bipartisan Policy Council at the Capitol years ago. So, Jason, I'm really pleased and proud that you and Bill have carried on the tradition here. So, hopefully, there will be more of a generic operation that's in the nature of a Bipartisan Policy Council soon on Capitol Hill. So, with that, I thank you very much for your time and attention. Look forward to talking further.
Yeah, thank you. Well, I have to call you Mike, not Attorney General Hunter, because we have a little history. It is nice to welcome you back to the swamp. We decided to provide a cold driving rain just to reacquaint you.
It's like home.
So I'll also just note for folks that Mike indicated that he spent several years at the American Council of Life Insurers and the American Bankers Association. We had a chance to work really closely during those years. You will remember that during your time at the American Bankers Association, it was those quiet years following the Dodd-Frank law.
Very tranquil.
And something that I think is important to your character, and I think it was clear on stage, is that when we were in the room with a lot of people professing their mortality based on every single thing that the government was contemplating on that day, Mike was always the, well, hold on, wait a minute guy. Mike was always the person who tried to figure out what was the emotion and what was the substance in those different arguments, very consistent with the kind of evidence-based imagination of public policy that we have here at Bipartisan Policy Center. And I think it seems that you're bringing that same kind of focus to your public service in Oklahoma, which I'm sure the people there and we all do appreciate. So let me just kind of start in with just the basic question that, you seem like you have been kind of at the reluctant legal vanguard of this issue. Were there times as you were moving into this legal theory when you were, I think, grappling with what you explained was your own kind of ambivalence about the use of the law, where you thought, maybe it's not worth it, maybe we shouldn't go through with it?
Am I under oath?
This is a private Twitter-free zone with the wonderful people at C-SPAN covering your every word. So, your thoughtfulness.
Well, it's been tough. As I mentioned, Cheryl and I just went through an election last year, and I'm not accusing anybody of anything, but the extent to which this lawsuit was part of the discussion during the election was certainly regrettable. And one of the things that you have to take into account, if you're self-aware as a candidate, as somebody in public service, is these things really impact your family in a way that is more unfortunate than they impact you. And so that was something that certainly gave me pause. When you're, there's this view people have, ordinary people, that why don't folks in public service just do the right thing? What you find in public service that doing the right thing is sometimes very, very hard to do. You're dealing with vested interests, you're dealing with money, and money may not be the root of all evil, Jason, but last couple of years, my experience is that money makes people sometimes do very bad things.
So something else that we've found here at the Bipartisan Policy Center, where we spend a lot of time trying to put together creative outcomes like this settlement, is that no one likes anybody else's creative outcome. It seems that you have architected a settlement which is unique in a lot of the very thoughtful ways you described, but I understand that people in the state all have their own imagination, right? Your legislature didn't love the notion of an attorney general making these kinds of decisions that they thought were, the domain of a legislator policy. How's that been working out for you?
Well, a few days after the settlement was announced, I took the time to address each of the various caucuses, House, Senate, Republican, Democrats, and rose petals were not strewn in my path. There was great consternation over me going around the appropriations process. And complicated things are sometimes a challenge, particularly when people have made up their mind that this is simply a situation where you have gone around the appropriations process. And so I emphasized and have emphasized over time that the options were not the appropriation process and the settlement. The options were zero, Purdue declaring bankruptcy, because as I said, if I were providing legal advice to Purdue, I would probably already have them in bankruptcy, because they're in a position where they've got to manage their liability here, and their liability is mammoth. So they were, we felt, earnest in their admonition to us that they were not going to trial in Oklahoma, that bankruptcy was an option for them. So in trying to avoid a zero outcome, what we came up with was a settlement with Oklahoma that had national significance, that is meaningful, that will play an important part in dealing with the epidemic, not only in Oklahoma, but for the rest of the country. And we were able to convince them that that was an appropriate and thoughtful and pragmatic way for them to avoid a trial in Oklahoma and a judgment that they'd have a difficult time managing. So over time, the legislature has, I think, I don't want to say they've been mollified, but
they've warmed to your...
to a certain extent.
So let's talk a little bit about the settlement. You obviously have an immediate crisis in Oklahoma, and then as you described, we have this longer-term national crisis, which is certainly, if it's starting to crest, it is certainly not abating, and I think there's a lot of concern that it will still continue to get worse before it gets better. How is the settlement managing the need to focus on this kind of clear and present immediate challenge versus the longer-term ambition that you described?
So it's a good question. Again, one of the considerations here is getting funds as a consequence of the settlement that can be deployed in real time. And the OSU program is up and running. It's it has momentum. What they're going to be able to do is they're going to be able to add fuel to what's already underway in the context of treatment, rehabilitation, ensuring that OSU has an unusually, I guess, relevant mission with regard to Oklahoma, because it has a network that connects them to small towns and rural communities around Oklahoma. So that's going to be, and we thought it was a real selling point for Oklahoma State, given the fact that we have principally still a very small town, a rural complexion to the state. But we'll be able to get those funds deployed. Oklahoma State will be able to get those funds deployed. They'll be able to, in a very value-add, turbocharged way, begin deploying support and services around the state in just a few months. So that was an important part of consideration and why we settled as opposed to going to court.
So you've mentioned, and I think people are familiar with the expansive liability that these companies are facing. There's about, I think, 1,400 suits being consolidated, you mentioned, in Ohio, and I know that's not your case, but do you have any thoughts you can share on just how you see the national legal discussion moving forward?
Well, I think it's a real challenge to accommodate political subdivisions in a way that you simultaneously are dealing with the state issues, because there's so much overlap, and it's difficult to distinguish between the two. But what we've done in Oklahoma is we have acknowledged that cities, towns, and counties are going to play an important part in dealing with the epidemic. I mean, you're going to have community availability for rehabilitation and treatment, and in many ways they've been in as forward a role as anybody. I mean, Bill mentioned the challenges of the Osage Hospital. So there's a set aside in the settlement with Purdue of $12.5 million. Where we go from here is we believe that political subdivisions are going to play an important role in dealing with the epidemic in Oklahoma, but a real challenge in coming up with some kind of a consensus outcome in the MDL in Ohio is, again, how you're able to harmonize the interests of cities and counties with states in a way that makes sense and allows the entities to work together in a collaborative, coordinated way. And I understand they're struggling with that. We think we've got a good approach in Oklahoma.
So I have a couple more questions we want to ask you all to think about. Some questions you might want to pose to the Attorney General. Just stepping outside of the legal discussion, you've now been very engaged in just this crisis in Oklahoma. Can you say a little bit about how you see the federal and state and local governments collaborating? This kind of idea of collaborative federalism is something we often aspire to here, but I think not always as easy to achieve.
Well, in Oklahoma, we are enjoying, I think, a real renaissance in how we're working together with the federal government. The U.S. Attorney's offices work closely with us. We work closely with the FBI, the DEA, and the other entities that have a role in dealing with the epidemic. And so both state, county, municipal, as well as federal law enforcement are really working together seamlessly. With regard to the money that's being deployed, Jason and I were talking about that earlier this morning. There wasn't a whole lot of, I guess, systemic consideration with regard to deployment. But over the last 3 months, we've seen a lot of good outcomes. We've seen a more focused approach, just based on people coming up with some approaches that make sense. But the federal government's role here is important. I don't want to get into any kind of a 60 minutes approach to how the federal government could do things differently. We've got to be forward-looking. The DEA, the FDA, those entities need to learn from this experience, and it needs to not be replicated, because there was definitely some lack of, I think, awareness and a lack of sensitivity and a lack of the appreciation for the seriousness of the epidemic in past years. But again, it's not helpful to look in the rearview mirror. We need to deal with what we need to deal with and not curse the darkness. So I hope that we all learn from this, federal, state, and political subdivisions.
So as we turn to the audience for questions, I'll just a moment of somewhat informed, optimistic reflection about this swamp is that the opioid issue is one of the places where the Congress are actually working together quite effectively. It's slow, but I think last year and last Congress there were some real meaningful resources moved to the states. And I think one thing that Mike referenced is that the BPC did a pretty detailed analysis to try to figure out what was happening with the money, because as is often the case in emergency, Congress will move money out the door without much of a mechanism to figure out where it was going. And we came away, frankly, encouraged that the resources do seem to be flowing to the places in the country where the crisis is the greatest. The next step is now to look at the efficacy of those interventions. But there are not a lot of moments here in rainy Washington when we can speak with some pride about our congressional competence. And I think this is at least an area where we're moving in a decent direction. Sir, I think we have a question in back. And please let us know who you are.
My name is Carl Polzer, and I started a project called the Center on Capital and Social Equity. And I look at how to include the average guy, the deplorables that are favorable to both parties, in the economy. So that relates to my question. And congratulations on the settlement you came up with that's practical and doesn't put the company out of business. It reminds me of the Rainmaker novel, the issue in that novel. My question is this, though. A lot of individuals were injured, and some of them will be able to recover through the state, through the university, some of the injury, that we get some remediation. Does this lawsuit prevent is there any kind of deal where the other individuals can't sue, or there can't be a class action? And in other words, the role of the individuals and the regular people, does that create a lot more liability potentially for the company as well? Are they interlinked?
Yeah, our settlement with Purdue Pharma doesn't abrogate any individual rights of recovery for citizens in our state. One of the things that I should have mentioned is there is significant injunctive relief that is part of the Purdue settlement. They are prohibited from any kind of marketing or promotion of opioid analgesics in the state into perpetuity. But to answer your question, any release or settlement that the state enters into in no way affects the rights of individuals to bring lawsuits.
Other questions? Please sit right here, and then we'll come over to the side.
Good morning, Mr. Attorney General. Andrew Kessler with International Substance Abuse Counselors. Oklahoma is a state, like many others, where we have a workforce shortage of professionals who can provide prevention, treatment, and recovery services. Is there any opportunity in these settlements that some of the funds could go towards the training of professionals across the spectrum in order to enhance the infrastructure we have to provide treatment for those who need it?
Yeah, with regard to Oklahoma State programs, we have 2 medical schools in the state, and the only medical school that's providing training for physicians who are going to do medically assisted treatment occurs through OSU. And just in the last couple of years, I think they've trained an additional 130 physicians through the Health Sciences Center. So that's going to be an important part of how these funds are deployed to ensure that we've got people who are trained to assist folks in dealing with their addiction and getting them better. So it's a good question. Thank you.
Question here on the side.
Hi, Paul Demko with Politico. How would you handicap the likelihood of a broader settlement before May 28th? And is the risk that you mentioned in the Purdue Pharma situation that they could declare bankruptcy and Oklahoma would be left with nothing a factor in those discussions?
So the two defendants that remain in this lawsuit are publicly traded companies. I don't see there to be a realistic potential of them declaring bankruptcy before May 28th. I'm very fond, in particular, of 3 presidents: Ronald Reagan, Theodore Roosevelt, and John F. Kennedy. As John F. Kennedy once said, let us not negotiate out of fear, but let us not fear to negotiate. So if the defendants want to sit down with us and have a conversation, all the mediation that have been scheduled in the trial, the mediations have concluded, but if there's an interest in talking, well, we certainly wouldn't avoid having a conversation.
Good. Time for one more question? All right, well, please.
Good morning, Jacqueline Hackett. So in Oklahoma, there are 18 residential drug treatment centers, about 550 beds. And I've read that you need about 250 more beds to meet capacity just for residential treatment in the state. How are you utilizing the settlement to ensure that there are treatment beds and all levels of care available on demand?
So the answer to the question is, with regard to the Purdue settlement, that had to be narrowly tailored, as I've described, to deal with the complexity of Purdue's financial situation and their bankruptcy opportunity. With regard to the remaining defendants, any judgment or settlement, those funds are going to be deployed in connection with and with the decisions of the legislature. Now, the legislature is going to have to act in concert with the judgment, the consent decree, or the judgment or the settlement with regard to the deployment of funds, because they've got to be directed towards abating the epidemic. So in a perfect world, a significant portion of these funds would be made available to get to the point where we've got what we think is critical mass with regard to beds and counselors and doctors who are helping people get better.
So, Mike, just a closing question. You are in the crucible of this, but project forward 4 or 5 years. What's your hope for the legacy of this last many months of hard work and challenge?
Well, there are 2 elements to the epidemic. One is overprescribing and one is oversupply. Overprescribing, we feel like we dealt with. There's not only a prescription monitoring program in the state that's efficient and effective, we now have prescribing limits with regard to opioid analgesics. The oversupply element of all this is significant because there continues to be a lot of leakage when these pills are provided, when they're distributed. And that's a law enforcement challenge. So I'd like to look back on this and be able to state with confidence that with all the policy that we've been successful in implementing, with the lawsuit, that the source of the problem has been addressed, and then the consequences, the fallout from the problem is in a significant way, in a way that's proportional to the problem being addressed, again, by having appropriate availability of residential facilities, treatment facilities, doctors, counselors. We get people better. The public understands in a more fulsome way that addiction is a brain illness. It's not a sin. So I'd like to be able to look back and, with some feeling of accomplishment in the sense that we've dealt with a problem in a way that's successful, that we've abated the epidemic, people have gotten well, and we are hopefully going to be at a point where there are going to be 0 deaths from prescription drug overdoses.
Well, Attorney General Hunter, I want to thank you, I want to thank your family for the personal commitment you've put into protecting the interests of Oklahoma and for sharing some of those thoughts with us today. Thank you.
Thank you.
We are now going to transition to our panel. As Bill Hoagland mentioned, Regina LaBelle, who has served in a number of senior roles in the Office of National Drug Control Policy, is going to be moderating the session. I should also note that Regina is currently a distinguished scholar and program director of the Addiction and Public Policy Initiative at Georgetown University, and she is an anchor of much of our work on these issues here at the BPC. So Regina, thank you very much.
Good morning, and thanks so much, everyone. I want to thank our panel for being here to discuss this important issue, and to the Attorney General from Oklahoma for discussing his perspective. And as you said, which I think is a great setup to this, the settlement in Oklahoma has obviously significance for Oklahoma, but it really has national significance. And we're kind of entering this moment. For those of us who have worked on the opioid issue for a long time, this is a really important moment that that we are seeing before us, and we're joined by this distinguished panel. Abby Gluck is the founding director of the Salomon Center for Health Law and Policy at Yale Law School. She also has a great combination of law and public policy, also was an attorney in Governor Corzine's administration in New Jersey, worked for Mayor Bloomberg as well, and clerked for Justice Ginsburg. We're also joined by Marsha Lee Taylor, who is the Vice President for External and Government Relations at the Center on Addiction, and was previously the President and CEO for the Partnership for Drug-Free Kids. They're now combined, the partnership and the center, and served as a Senior Advisor for Drug Policy and Research for the Senate Judiciary Committee on Crime and Drugs, and was a longtime advisor to Senator Biden. And last but not least, obviously, is Matt Myers, who was a founder and president of the Campaign for Tobacco-Free Kids, and participated in the 1996 negotiations leading to the first tobacco settlement. So we have an opportunity today to discuss kind of the past, the tobacco litigation, what we can learn from that, the present, what all the opioid litigation, what we're currently facing, and then the future, which Marsha Lee Taylor will discuss because she has been working with several of her colleagues in the addiction field about what the money can be used for and how it can make a difference. So what we'll do first is I have a series of questions that we'll ask the panel to discuss, again, in keeping with the theme of past, present, and future. And then we'll have an opportunity for some questions from the audience. So we'll start with Abby. If you could provide a little bit of a landscape for the multi-district litigation and other major opioid litigation. So where is it headed? Where is it current? Where is it headed?
Okay, so thanks for having me here. So This is an unprecedented litigation, in part because of its scope. So there are about 2,000 cases that have already been filed. And in general, when you have a litigation of that kind of scope, it's impossible to try those cases individually, both because defendants can't be in 2,000 different courtrooms at the same time, and also because the defendants generally seek what is known as a global settlement, some kind of global peace. They want to resolve all their liabilities in one shot, if possible. That gets to that preclusion question that was asked earlier on this side about, can there be more suits after this suit? Defendants don't want to have suits one after another, and they seek this kind of global settlement. So in the federal court system, we have something called a multi-district litigation, which is a mechanism that allows lots of lawsuits to be consolidated in one courtroom. So 1,600 approximately of these opioid suits are now in a single federal district court in Cleveland before a judge named Dan Polster. That judge has been very upfront about his view that litigation for years is not the way to resolve this crisis. He's very focused on the fact that there's an ongoing crisis, and he's made many comments to the effect that he's seeking a very aggressive settlement. That's what's happening there. But as you've just heard, he's not the only game in town. And there are about 400 other cases that have been filed by cities and states. There are also pending Attorney General investigations beyond the state of Oklahoma. And Judge Polster doesn't have control over those cases, although he's invited them into his courtroom to negotiate in an effort to get that kind of global settlement. One interesting issue is this issue that lots of cities have filed lawsuits in addition to states, and that creates some complications for state attorneys general that are trying to resolve the issue for their state as a whole when they have these sub-locations, sub-localities litigating the cases. Oklahoma was an interesting moment in this litigation saga because it puts a lot of pressure, arguably, on that federal litigation to settle quickly, maybe even before May 28th, in response to one of the other questions we just heard, precisely for the reasons the AG just said, in the sense that there is a limited pie that all of these different defendant companies have, and the MDL wants to get its hands around that pie and wants to get as many different parties in that settlement as possible. I'll just say two more things, and then we'll save more for later discussion about the litigation. But two other pieces of the litigation landscape is exactly what the AG mentioned, this prospect of bankruptcy by Purdue on the horizon. I think the AG was absolutely right that that would pause the cases and bring everybody in front of a single federal bankruptcy court, moving us out of the state-federal patchwork of litigation. And the other issue is that we've had a new rash of cases recently involving criminal claims against representatives of companies for their involvement in the crisis, and some other cases that have been brought against the individual family members who own Purdue themselves, the Sackler family. So this creates quite a complex landscape.
Great, thank you. Can you just, picking up on that, and we'll go to Marcia next, can you briefly describe some of the legal claims we heard from the Attorney General about the nuisance or the...
Yeah, sure. So what I want to start out by just sort of framing this by explaining what's really unusual about this case is the number of different parties in the case. So on the one hand, there are the plaintiffs. So we've got states, we've got cities, we've got Native American tribes, we've got individuals. I already mentioned one of the complications that the cities and locality cases raise for the states. When it comes down to doling out the money for the remedies, there may be fights where some localities are saying, we're our own plaintiffs. State AG, you can't control where the money goes. We have our own claims. And in fact, I'm sure we'll hear more about this, one of the reasons we get these locality cases is that some cities and localities were unhappy with the tobacco settlement. They felt that the states put that money toward uses that were not targeted where they were most needed, and that is the impetus of some of these state cases. Now, on the defendant side, there is a huge range of defendants. We are not just talking about Purdue. We're talking about distributors. We're talking about, like McKesson. We're talking about Johnson & Johnson. We're talking about the Sacklers. We're talking about retailers like CVS and Walgreens. That sort of has two implications for the claims that are raised. One is that it makes a public statement that there's a lot of different people who are responsible for what's going on. That's a statement that Judge Polster has echoed several times, that sort of everybody's responsible for this is a line he's used a couple of times. Another thing it does is that it complicates the legal claims because you have to prove causation in a court of law, and you've got a very broad chain of defendants. And everyone's pointing fingers and saying, well, you can't prove that I caused the addiction because there's the FDA, there's the doctor, there are people who actually need opioids, like cancer patients, right? Then there's the distributor, there's a manufacturer, and on and on and on. So the way we get with the legal claims, there's a couple different kinds of legal claims, but they're fairly straightforward. Most of the states have statutes, federal laws on the books, that protect consumers from deceptive behavior. Many cases are being brought through those statutes. A number of cases are also being brought using federal racketeering laws, arguments that these businesses engaged in a pattern of illegal business activity. And then you've heard these common law claims that the Attorney General mentioned. Some are negligence, that a duty was owed to the public that was violated. And then there are these nuisance claims, the idea that these companies created a public harm, significant public harm. We've also got the criminal cases I mentioned, and then the efforts to go against the Sacklers for their own money, not just the company money, on the ground that they knew something was afoot and they were pulling money out of the company so that there'd be less left for the lawsuits. So on the defenses, this goes to the nuisance question. The defendants have basically argued a lot of things, but they can be encapsulated, I think, in sort of 2 points. The first point, again, is this chain of causation point, that there are, unlike tobacco, there are valid uses for opioids. People need them. Some patients really need them. And they're approved by the FDA. They're prescribed by doctors. They're used by people. There's a long chain of causation, and it's very hard to point to any individual defendant, particularly those further down the distribution chain, when it comes to causation. On the nuisance claim, and I'm going to talk about the federal MDL, since the AG already talked about these state nuisance claims. In the federal case, one of the defenses has been that to the extent that there's any duty owed to the public by companies that sort of traffic in controlled substances, that duty has to be enforced by the Department of Justice, because the federal law, the Controlled Substances Act, imposes that duty on those companies, and so it's the federal government, not the states and individuals and all the other plaintiffs, that should be suing to enforce those claims. So those are sort of the primary framework.
Great, thank you. Marcia, you helped spearhead what's called the opioid settlement priorities, and so this is going to the future. Tell us where, what you came up with, you and other colleagues came up with about what the future should hold.
Sure. Well, thank you. It's great to be here today. This is such an important topic. The Opioid Settlement Priorities document is a series of recommendations that was put together by the Addiction Solutions Campaign. And the Addiction Solutions Campaign is a consortium of the Partnership for Drug-Free Kids, the Center on Addiction, the Legal Action Center, and the Public Health Management Corporation. We're 4 of the oldest organizations in our field, and we work on a number of issues together. And when we were talking about the litigation that was going on, we thought, you know, it really, if we're not going to put together recommendations, well, we should put together recommendations about how the money should be spent, because we have a lot of ideas here, and want to make sure that there is a document out there that people can turn to and look to as this discussion is going on, and really have it be a blueprint for how to change the trajectory of the problem going forward. And one of the things we have going for us on the opioid epidemic is that we know what to do. Unlike so many other enormous social problems, we actually have a lot of evidence-based solutions where there's a lot of agreement about the direction that we should go in. And the question really is, as we look at opioid settlement dollars, is are we going to fall into the path of the tobacco settlement, which I know Matt will talk about more, where a lot of the dollars went to unrelated budget gaps, or are we going to dedicate the dollars to a series of well-intentioned Band-Aids that do some good but don't really change the system. And so the document that we put together was a blueprint of how to change the system. And it wasn't something that we just kind of came up with out of the blue. These are well-trod ideas that have been in the Surgeon General's report that was released at the end of the Obama administration, as well as the Christie Commission report that was released during the Trump administration. So these are not partisan ideologies, great things to be talking about at the Bipartisan Policy Center. And the impact areas that we developed in the report really fall into 3 different categories. The first is to enhance public and professional education to really create a demand for evidence-based solutions. For so long, policies have gone in the wrong direction. because we've had misguided views about the roots of addiction. As the Attorney General said, people have thought about it as a sin, not a disease, and we need to change that, and we need to really create those basic building blocks from which everything else can grow. So some of these, some examples of investment areas would be having a public education campaign for families, so they understand the risk factors and the protective factors for kids, as well as what to do if their child develops a problem. Creating a consumer's guide for treatment, so that finding help for a loved one isn't such a shot in the dark as it is right now. Informing the public about the Parity Act of 2008. It's been more than a decade since the law passed, and consumers still don't know that they have rights to insurance coverage for mental health and substance abuse treatment. And that's so important to make sure that that gets out there so that people can challenge their insurance companies if they're denied coverage that they very likely are entitled to. The second bucket of priorities is around prevention and early intervention. We know that addiction is an adolescent onset disease. 90% of addiction starts in the teenage years. So if we can take the steps as a society to make sure that we're preventing and intervening early, we will take an enormous step to eradicating this illness. Different priorities here would be to take a page out of the tobacco playbook by looking at taxation and marketing restrictions for legal products. Taking prevention programs really seriously. Prevention is, unfortunately, has been chipped away at for years and years and years, and it is too often an afterthought in schools, and so instead of having an intense and evidence-based program, oftentimes it is a day or two in health class and not using evidence-based approaches. So really making sure that we have the infrastructure, both the human infrastructure and the curriculum needed in middle schools and high schools around the country to make sure that every child graduates from high school with a adequate prevention basis. And then really furthering screening, brief interventions, and referral to treatment. We know that intervening and referring to treatment works, but we need to educate healthcare professionals to be able to do this and incentivize them to do so. And the third bucket of recommendations focus on treatment, and it would be expanding access to evidence-based treatment, and really importantly, integrating treatment into the mainstream healthcare system. There are a number of good a number of good addiction treatment providers, but they're operating within a system that is fundamentally broken and under-resourced. And we really need to, instead of just pouring dollars into a system that isn't providing quality care, make sure that we're transforming the system. So some of the recommendations in this category would include increasing treatment capacity by making sure that every healthcare professional has a working knowledge about addiction, and making sure that all prescribers graduate from school being able to, having the training required to prescribe medication-assisted treatment. Also using licensing requirements and payment models to drive quality and care. And then finally investing in peer and family recovery services to make sure that people have the support that they need. And I think with some of these recommendations, we really can transform the system and make sure that going forward, we are better equipped as a country to be able to handle addiction.
Thanks. Matt, tell us tell us about the parallels first that you see between today's opioid litigation and your experience with tobacco litigation.
Sure, thank you. This is an important discussion. I'm the one person who doesn't really know that much about opioids. But one of the things that I think is important to recognize is that you only get to litigation because all the other systems failed. Litigation is not the place where we want to solve complex public health problems, and both tobacco and opioids is a set of complex public health problems. Having gotten to litigation, it strikes me as there's a critical set of similarities. While Abby was correct, a fundamental difference is that there's no positive use of tobacco. There is a positive use of opioids under the right circumstances. So when we ask ourselves, what are the parallels of why we're in litigation and what can litigation accomplish? I think we've hit each of the buckets, but not explored them in depth. The first is a prevention function. How do we use litigation to prevent this from happening in the future? You know, Attorney General Hunter talked about injunctive relief. It is incredibly important when we're talking about injunctive relief here to ask a core question, and that is, we're dealing with somebody who was engaged in both cases, massive wrongdoing. How do we make sure this doesn't happen again? How do we use the litigation tool to accomplish things that we know if we drop into the legislature will result in the kind of compromise weakness that won't truly create the kind of guardrails we need? If we haven't created an injunctive set of injunctive relief that will make it very, very difficult for this to happen again, we haven't accomplished our goal. Second, harm has been caused, and how do we use the litigation tool to not only create the funds, but the mechanism to maximize the likely result in terms of actually treating it? There is this extraordinary tension, and Attorney General Hunter talked about it, and we heard about it constantly in tobacco, of legislators saying, don't step on my toes. Of course, they're not saying, one of the reasons you're being forced to step on my toes is that I haven't done the job in the past, and I'm easily diverted. You don't have to get into that debate about the past, but what you do have to do, and one of the really bad lessons learned from tobacco, is that if the lawsuits don't result in very, very clear, very mandatory ways for how the money is going to be spent that directly addresses the problem, the legislators are likely to lose interest pretty darn rapidly. And so your second measure of success is, have you come up with a set of guidelines, rules, mandatory spending that ensures this money is going to be spent on addressing the problem that brought you to here in the first place? And that's not easy, and it is a political tension, which also brings me to a third parallel. We think of these things as lawsuits, but we have to think of them as public campaigns. When you bring this kind of lawsuit, you are really talking about a public good. If you don't bring along the public health people involved and treat it as a campaign, you won't have the public support for what's necessary to do in the end. It isn't a liberal or conservative issue, it strikes me, when you're dealing with these issues, but it is a public health issue. It is different than other lawsuits. You're going to be forced to make hard choices. And if you haven't brought the public along, if you don't have a broad base of support understanding what you're doing, then when you push for really strong action, you may not have the public support that's necessary. At the end of the day, in treating this issue, it strikes me, no one should feel comfortable criticizing mandatory spending to address this issue in the most effective way possible. And anybody who tries to divert the money or do something less than that should be held up, for public scrutiny. And then the last and the most challenging is accountability. Wherever you fall on the political spectrum, we do know that under the pressure of profit or the pressure of greed, some people became billionaires selling tobacco, and some people became billionaires over prescribing opioids. How do you change the mindset that says that's a risk worth taking, whether you're a corporation or an individual? And that is the place probably where the political calculus gets the hardest. But we have to recognize that there is that pressure. And under the best case, there will be people in those corporations who say it's worth it for me. Do the Sacklers walk away billionaires? And if they do, does that mean that somebody else at the next opioid that we can't envision today says that's a gamble worth taking? And that is the hardest political set of decisions, I think, because it does hit into a number of areas. In tobacco, tobacco companies have paid They haven't paid them as much as people think. But they have probably, in the first 25 years, will pay somewhere between $175 and $225 billion. You know what? It had no impact on shareholders whatsoever. Profits went up, not down. And therefore, did you really change the incentives of those companies? It didn't change. Not a single executive was held responsible. So does it change the mentality of an executive as you move forward on these issues going forward? One of the differences is on the opioid crisis, the people who caused it are still alive. And in some cases, they're still in the companies, making money off of it. In tobacco, by the time these cases came around, the people who made the initial decisions, and by and large, were gone. With regard to it. People were still making decisions to do wrongful things. That is, I think, the most challenging area, and it's the one area where we haven't had enough debate. So we can create guardrails, injunctive relief. We can come up with better rules about how we spend the money to address the problem. But the most challenging debate that we never have is how do we change the mindset of the companies, the shareholders of the companies that are publicly held, or the shareholders of the companies that are privately held, to say, that's not a risk worth taking in the future. And that is probably among the fundamental flaws, the most serious and the most challenging, because it does cut across views. It isn't whether you believe in capitalism or don't believe in capitalism. It is how do you make capitalism work? And when they do the plus-minus debate, come out in a way that says, I'm not going to gamble that I'm going to become a billionaire at a cost of a massive public health crisis. And today we're talking about opioids, and we can't envision what the next one is. But I'll guarantee you there will be a next one, because it is human nature and how our system works.
Thanks. Matt, I want to stay with you for just 1 minute because I want to pick up on that thread about, because I think that my next question to you was what the lessons are that you learned from tobacco litigation, and it sounded like it might be the accountability piece. So if you could expand on that.
Well, I think there's a number of really important lessons. One is, and let me just tick them off quickly. One is the public health community never agreed on what the proper relief was. Their disagreements created a weakness and a path to less than optimal results. So there is real benefit of people trying to agree early on goals so that the debates are narrow going forward. That's a lot harder than you think. Two, there was the constant pressure of what's the role of the Attorney General and what's the role of the legislature. In the case of tobacco, the failure to mandate how the money was spent has truly undermined the goals set out in the litigation. There is no way around it. The Attorney General said they brought the case to deal with the tobacco crisis, and then they didn't spend the money for dealing with it. In the few states that did, you saw dramatic and significant results. And in the vast majority of states that didn't, we have paid the price forever. Having said that, the tobacco cases were revolutionary. When the first lawsuit was brought, which was 25 years ago this month, cigarette smoking rates among high school kids were over 36%. Today, they're 8%. Smoking rates among adults were well over 25%. Today, they're around 14%. By any definition, those cases created a revolution that went beyond the narrow focus of them. But if you ask the question of could they have done much more, boy, absolutely the answer to that is yes. And then the third category is the one you talk about, which is they didn't change the mindset of the companies. The mindset of the companies remained, what can I get away with? How do I maximize profits? What can I get away with? The system didn't change how shareholders behaved, and they didn't change how executives behaved. And that is the most difficult issue to address long-term going forward with regard to these issues.
Thank you. Abby, I want to come back to you, and if you could talk to us a little bit about how the litigation that's before us fits in with the broader policy changes that are underway in addressing and reversing the opioid epidemic.
Sure. I mean, let me just, if I may, let me just also just say in response to what Matt just said that I know we're talking about the civil litigation here, but we are getting these criminal cases, and that has been a really interesting development. And so it may get at this, am I going to be held accountable individually for my role in actions like this? So I think the criminal development is an interesting development to watch, and it contributes to the civil cases atmospherically. It sort of shows the public has an appetite and a desire for, conviction and punishment, and so I think it does help the momentum of the civil cases. With respect to litigation, in the federal MDL, in the Cleveland case, one of the first things the presiding judge said was, this case shouldn't be here. The legislatures have punted. They fell down on the job. This really is a legislative solution, and we're stuck with it, right? So we're going to do what we can do. So I say that because I don't think there's any health law professor out there who would say that litigation is the solution to a public health crisis. So the question is sort of how can litigation fit into the broader policy landscape? And I think so far we've seen a couple of important benefits of the litigation. One is that it's definitely ratcheted up public attention to the crisis. It doesn't always happen that litigation is making the kind of front page news that it's making, but it's making it. We're going to have a nationally televised trial. It's really attuned the public's attention to the crisis. It's also already prompted industry change, right? Doctors are already prescribing a lot fewer opioids, in some cases too few opioids. We now have a crisis of underprescribing again in some limited circumstances, places where people with cancer aren't getting the treatment that they need. Some of the industry companies have already tried to preemptively make changes, sort of in a showing of good faith, and I think in the desire to mitigate the punishment they're going to receive. And any litigation settlement is going to involve some promises of industry change. That's the adjunctive relief we've been talking about. The litigation is also going to bring money, right? And money ties into the policy solutions we've been talking about. And the real question is, again, will that money be directed by the litigation specifically, or can the legislatures use that money to effectuate the kinds of policy solutions that were just talked about? Will money go to the people who are poor, who need treatment? Will money go to people in prison who don't have access to medication-assisted treatment? There's always been a danger of courts making those decisions. Courts aren't public policy experts. Yes, in Cleveland, there are a lot of smart people in that courtroom, but are they the right ones to make the decision? I worked for an AG before I was a law professor, and I agree that, specific settlements are the way to go here. But the question is, who's going to make those settlements? The other question is, going to the policy solutions that were recommended, will any money be received go to trying to force doctors and insurers to provide more mental health treatment up front, or provide alternatives to opioid treatment on the back end, things like cognitive therapy, physical therapy. Those aren't currently covered by insurance in many situations. So is there something that a settlement can do to encourage, even force, insurers to cover those kinds of services so that doctors don't have to rely on the cheapest resolution, which is prescribing an opioid? Now, let's put all of this aside. Frankly, in my view, and I'm thinking, just for myself, a state that wants to help resolve the opioid crisis should expand Medicaid, right? The court can't order that. That's not part of this litigation. We also have a crisis now, a third wave of this crisis, which comes from fentanyl, right? Which is a illicit substance, synthetic opioid manufactured in China. It's very, very dangerous. Fentanyl is often added to what looks like a regular prescription opioid, and in that combination can be fatal. It's extremely powerful. We have a criminal justice focus on fentanyl that has to be ratcheted up, but this next wave of the crisis is going to involve dealing with that criminal substance that won't be resolved by this civil litigation either. There are also states that have passed a panoply of laws related to doctor prescribing, related to access to overdose use. Those are important. The question is how much Judge Polster can get his hands around. We have federal laws that get in the way. We have federal laws that prevent where people with addiction can be treated. We have federal laws that prevent how many people a doctor can treat with opioid use disorder. And I completely agree that getting at those barriers are very important. Can the judge in Cleveland order that? I think we're going to see something very ambitious. I think he's going to try to do as much as he possibly can, but the question is just how far he can go. And I'll just conclude by saying, one thing about litigation in general, which is that, on the one hand, people worry that litigation will take the wind out of the sails of real policy reform. You had this big litigation, billions of dollars are going to be paid, maybe Purdue will go bankrupt, done. Solve the opioid crisis, let's turn to the next problem. That would be a tragic outcome of this litigation and this effort, right? On the other hand, litigation can sort of bring money in, ratchet up attention, turn state and federal legislatures to the problem, and that will be a very positive outcome of what's happening across the country. And I'm optimistic that that's what litigation is doing in this instance, certainly not in every case, but I think in this case it has had a benefit.
Can I just add one quick thing? Because I think what you point out is a very important thing. In this case, the attorney generals, who are in a better position than the private lawyers, can't think of the litigation as narrow litigation. It is a public health campaign, which they are in a position to lead, including a position to draw very broad public attention of the kind of remedial action and change that's necessary. So that if they think of it narrowly as litigation and what a judge orders, then they'll never have the public support of either the legislators or key people who don't get going forward. If they see it as their opportunity to step forward and create a public dialogue and a public discussion, then things become possible that weren't otherwise possible, including the discussion of why we're doing what we're doing, the choices we made, the options we had to consider, why these kinds of issues become really very important. So they have an opportunity in a forum that puts attorney generals, I think, in a uniquely different position here. But they have to see their dual role. They're not only lawyers, they're public officials with an opportunity to wrap their arms around an issue which they didn't go looking for. It got dropped in their lap because of a series of other failures, but which they are in a better position to address, I think, the public discussion, including not only about wrongdoing, but where we go from here. Including, the very important discussion of people who are addicted are not the wrongdoers themselves. And we need to change that mentality. Who is in a better position to do it than our nation's chief law enforcement officers?
So that's a perfect segue to Marcia, the non-attorney on the panel, to talk about how litigation is a spark to action. And I think that's what we've talked about here. So how do you balance the needs of today when we have more than 90% of people in America with a substance use disorder who don't receive treatment, and kind of paying the costs of the epidemic that have been borne by state, local, and federal governments?
Well, I think that helping people right now who need treatment to get it is incredibly important. But I think that needs to be balanced out with making that structural change that's going to help people into the future and is going to make our entire system more responsive to addiction as a disease. I think that a lot of the localities are looking to recoup their losses, but I think that allowing that to happen, at least as a major dedicated effort of any litigation dollars or any settlement dollars, would be an enormously wasted opportunity. I think really focusing on people who need help today and making change for the future are the really important directions that the dollars should be spent in.
Great, thanks. So we have time for a couple questions from the audience. Go ahead. I don't know if we have a mic.
My question is addressed to how did we get here? And there certainly has been criticism of the FDA and for having permitted labels that were excessively optimistic, and of the Obama administration for not responding in a timely way. Are those criticisms valid?
So I'll let the panel discuss the first question on the Obama administration. I think it's important that we look at this from the three waves of the epidemic, and it really began when OxyContin was introduced onto the market, which was in the 90s. And so I think it's, this is a bipartisan issue that takes a bipartisan solution, and it's not one administration we can point the finger at. Okay.
I would say it's really a perfect storm of issues. This is really an example of the worst case scenario about the medical community not being educated about addiction and not being educated about pain medication. Those are the two things that doctors don't learn about in medical school. And the chickens came home to roost here with that knowledge gap. So I think that was a big part of it. I think also just our societal views about addiction, all the stigma that comes along with it, I think made us slow to act. That it must be something that people did wrong because we've seen it as a moral failing rather than as a disease. And I think what managed to change the tide on public perception was so many quote-unquote good kids who had a sports injury who wound up getting addicted, and unfortunately people saw them in a different light than individuals who became addicted during the crack epidemic in the 1980s. That was something that those people did wrong, whereas the lacrosse player that has a knee injury and gets addicted to the pain medication, made people re-examine some of their biases. So I think that the origins of the problem were different than in a lot of other epidemics, but also the way people perceive the problem was very different as well. And hopefully we'll have lasting change. We see a stimulant epidemic coming down the pike. It's breathing down everyone's necks right now, and we know that that's going to be the next wave, and it will be interesting to see if public perception has permanently changed on this, or if it will be more of the same, if the population that's hit is different.
If I could offer sort of a structural perspective on it, I mean, I think that we started, with this arguable epidemic of undertreatment of pain in the 1990s, and that led to a variety of initiatives to increase pain treatment throughout our system. But structurally, there were incentives that made where we are more likely with the way our healthcare system is structured. So one of the things, the question we all get, rate your pain on a scale of 1 to 10, that's a direct result of the way that hospitals get paid, right? So back in the 90s, the idea was to encourage physicians to be attentive to pain. There are these consumer surveys that consumers fill out that basically rate hospitals on their performance, their satisfaction. Hospitals get paid as a percentage of those survey results, basically a calculation based on those survey results. Pain was incorporated. Did your doctor ask you about pain? Was your doctor attentive to pain? So of course, everyone was told, be sure to ask your patients about pain. Be sure to be attentive to their pain. That's a structural incentive that goes to the way we pay for healthcare. Similarly, more than half of Americans get addiction treatment from their primary care physician. Primary care physicians have something like 11 minutes devoted per patient per day. They don't have reimbursement codes that allow them to get paid for things like behavioral therapy. They can, in 11 minutes, they can ask you about things. They can prescribe a pill. They can send you on their way. And as I said before, they're also very cognizant of what their patients' insurance companies are going to pay for. And as many of us have experienced, your doctor might say, what insurance do you have? Well, maybe I could give you this kind of therapy, maybe I can't. You might not get it covered. Let's talk about the options. And the pill was sort of the way to go. I also would just point out that addiction as a medical specialty is only, I think, 3 years old. I think 2016 is the year that it was formally recognized. Of course, we had psychiatrists. Of course, we had addiction specialists. But as a subspecialty of the medical profession, it wasn't even recognized as a subspecialty. And so we're late to the game here. And I completely agree that all medical students should be getting this kind of treatment. It should be part of the medical school curriculum. They're moving there, but we hadn't been focusing on things in that way. And the last thing I'll say structurally is also that even though someone mentioned the mental health parity laws, like it was you, yeah, we've had that law since 2008, and it's not enforced right? That's AG should enforce that. The federal government should enforce that. We have these laws. We're supposed to have equal access to mental health services, and people still don't get that kind of equal access to mental health services. And that's all part of the perfect storm on the legal side of how I think we got there.
Thanks. Any other questions? Questions? Anything else from the panel you want to add before we close?
No.
I just, one thought that is a lesson from tobacco. That is one of the very difficult things for those who litigate these cases. As lawyers in a courtroom, they face very practical and real limitations, which the community doesn't understand. And there is this very difficult balance about creating bold goals and doing things that you can do there that you can't do otherwise, with a firm public understanding of what really is possible under a best case scenario. And this goes to the nature of the public discussion. If you're going to both maximize what you can accomplish and then defend it when you do. In the tobacco field, the lawyers litigating the case saw the limitations, saw the weaknesses, and set initially a set of goals that were way beyond what they could have accomplished in their legislatures, and even normally through a trial. They didn't do a good job of explaining to the public where those limitations and guardrails were, so that there were a host of people who had completely unrealistic expectations of what could be accomplished. And if you're going to accomplish the maximum amount, often what goes beyond what you could accomplish in a trial and a judge could order in the absence of a settlement, you're going to have to explain those things really well. And that's, again, the recognition when you walk into court in these cases, you've got a set of legal issues, but you also have a public policy set of issues out there. And to figure out how you maximize the two and bring them together requires lawyers to step outside their comfort zone in doing those things. And at the same time, for lawyers to think bigger than they're used to thinking about just what could a judge order. Because in a settlement, you can think about, how do I push the system further? You have maximum leverage with companies who've been caught doing the wrong thing, who have sometimes an incentive or at least a fear that if they don't do more than what a judge could order, they could be in worse shape. And so there's this real tension and balance, but how you play it out could have a great deal to do with whether you bring about the kind of fundamental change that 20 years down the line, you will look back and say,
describing the theory of your case and why this is so important to people in Oklahoma. Appreciate you being here. And I thought the panel was tremendous. Thank you for all of your insights. Helps us understand the litigation landscape, how we can effectively use these resources, and also, Matt, what the lessons are from the tobacco master settlement. Thank you, Regina. The questions were terrific, so really appreciate all of the audience participation and the questions. This is an important issue, and I think we're going to be tracking it here at the Bipartisan Policy Center, and more broadly, trying to continue identifying bipartisan solutions to respond to the opioid epidemic. Bill mentioned we just released a report in March, the first comprehensive, transparent analysis looking at all federal funding going to states for 2017 and 2018. So please, if you didn't get a chance to see that, please feel free to take a copy of that report. So thank you again. I want to acknowledge Morgan Bailey, Tim Swope, Joanne Donnellan, and others from the BPC team. Appreciate all of your efforts in putting this event together. Great to see all of you here, and looking forward to seeing you next time. Thanks, everybody.